December 2025. Gun laws are changing in real time across America, not next year. Right now. The Supreme Court just agreed to hear TWO major Second Amendment cases. Hawaii's private property ban, drug users and firearms, and Bruen's ripple effects are still tearing through state legislatures. But hear what nobody was telling you while everyone is focused on what the Supreme Court might do. 10 massive changes have already happened that affect you today. If you own guns or believe the Second Amendment still means something, the next 15 minutes will show you exactly what changed and what you need to do before these new rules affect you. Let's break down the 10 gun law changes that just rewrote American firearms rights. Change number 1. The Supreme Court is deciding whether you need permission to carry into private businesses. Hawaii's 2023 law flipped the script. Old system, carry your gun into stores unless owner posts no guns. New law, you cannot carry onto a NY private property open to public unless owner gives express permission first. The Supreme Court agreed to hear Wolford v. Lopez in October 2025. Oral arguments expected early 2026. Why this matters. 5 states have similar laws: Hawaii, California, Maryland, New Jersey, New York. Trump administration filed brief calling these laws unconstitutional. The DOJ said you can bring bicycles, muddy shoes, dripping umbrellas without permission, but guns require authorization? That's discriminatory. Circuit courts are split. Ninth Circuit upheld Hawaii's law. Second Circuit struck down New York's identical law. Supreme Court had to take this case. What this means: decision expected June 2026. If gun owners win, default becomes guns allowed unless posted. If states win, more states will adopt Hawaii-style restrictions. Change number 2. Can regular marijuana users own guns? Federal law says nitrogen monoxide, but marijuana is legal in 24 states for recreation and 38 states for medicine. Yet federally, it's Schedule I. Millions of Americans who legally smoke weed are felons under federal law if they own guns. October 2025. Supreme Court agreed to hear United States v. Hamani. The case: Ali Daniel Hamani, regular marijuana user in Texas charged under federal law. Fifth Circuit ruled the law unconstitutional as applied to regular users. Government must prove person was under influence at arrest, not just regular user. Trump administration is defending the law despite being pro-gun. They argue drug use impairs judgment. Circuit split. Fifth Circuit struck it down. Other circuits upheld it. What this means: Supreme Court decision June 2026. If gun owners win, millions of legal marijuana users can own firearms. If government wins, enhanced enforcement likely. This determines whether 38 states' medical marijuana patients are gun owners or federal felons. Change number 3 already happened. March 2025, Supreme Court upheld Biden-era ATF ghost gun rule. Bondi v. VanDerStok ruled 7-2 that Gun Control Act allows ATF to regulate unfinished receivers that can be readily converted into firearms. What changed? All 80% receivers need serial number. Sales require background checks. FFLs treat them like complete firearms, grandfathered. Kits bought before March 2025 don't need serial numbers. Bottom line, you can still build your own, but now requires same process as buying complete gun. Change number 4 happened June 2024. Bump stocks are federally legal again. Garland v. Cargill. Supreme Court ruled ATF exceeded authority when banning bump stocks after Las Vegas shooting. Court said, bump stock doesn't convert semi-auto into machine gun. Congress must pass law. ATF can't regulate it. What this means: federally legal, but several states have own bans. States that banned: California, New York, Massachusetts, New Jersey, others. Key point: federal legality does not equal state legality. Check your state law. Change number 5 clarified exception. People under domestic violence restraining orders can be disarmed with conditions. United States v. Rahimi, 2024. Court upheld federal law prohibiting guns for those with restraining orders, but only when order contains finding of credible threat to physical safety. 2 categories. With credible threat finding. Constitutional disarmament without credible threat. Status unclear. Iowa Supreme Court twist 2025. In State v. Cole. If someone consents to protection order with firearm restrictions, they waived Second Amendment rights even without credible threat. 62% of restraining orders entered by consent. That means most survive through waiver. Action. If facing restraining order, DON to consent to firearm restrictions without attorney. Change number 6 is pending. National Concealed Carry Reciprocity. H.R. 38, Constitutional Concealed Carry Reciprocity Act, reintroduced in Congress, would require all states to recognize permits from a NY state. Current, patchwork. Texas permit works in Florida, not California. Proposed, your permit works everywhere, like driver's license. Trump administration supports it. What this means: 25 permitless carry states equals carry anywhere. Permit states equals recognized nationally. CA, NYNJ would have to recognize out-of-state permit status. Pending, may take 2 to 3 years. Change number 7. May issue systems collapsing nationwide. After Bruen, 2022, states can't require proper cause, but some tried sneaking May issue back. December 2025 status. New York. CCIA mostly survived. Supreme Court declined challenges April 2025. Stayed, good moral character, sensitive places. Training struck. Ban on private property open to public. California, Maryland, New Jersey, Massachusetts, all facing federal lawsuits. Pattern. May issue dead, but states trying may delay and may obstruct. Action. Challenge excessive delays. Document everything. Change number 8. Courts narrowing what counts as sensitive place. Bruen said historical sensitive places, courthouses. Legislatures can ban guns. States went crazy expanding this. New York tried banning parks, playgrounds, transit restaurants with alcohol, churches, anywhere children might gather. Courts pushing back. These have nitrogen monoxide historical precedent. Founders didn't ban guns from churches or parks. Current status. Courts striking overly broad laws, only genuinely sensitive places likely to survive. Private property bans pending at Supreme Court action. Check your state's current law. Many restrictions being challenged. Change number 9. Courts saying excessive delays violate Second Amendment. Federal needs checks must complete in 3 days. States added own checks, creating months long delays. States under fire. Illinois, 6+ month FOID waits. Massachusetts, indefinite delays. California, layered checks. Washington, delayed processing. Legal theory. Everyday waiting equals rights denied. Recent developments. Federal lawsuits filed, courts issuing injunctions. States forced to speed processing action. If check exceeds 30 to 60 days, document carefully. May have grounds to sue. Change number 10. Mandatory training being challenged. Clear distinction. Training is essential for safety, but government can't use it as barrier. Courts asking, did founders require government-approved class before exercising rights? No. States under challenge. Maryland, 16 hours required. New York, multi-step process. California, various certifications. Connecticut, extensive mandates. Courts ruling, training can be recommended, not required. States responding, making training optional, reducing hours, eliminating live fire requirements, removing expensive fees. Important. Get training regardless of law, it's your responsibility. But $1,000 courses can't stop poor people from permits. That's unconstitutional. Immediate timeline, next 6 months. January-March 2026. Hawaii case oral arguments, Wolford v. Lopez. January-March 2026. Drug user case arguments, US v. Hamani. June 2026. Decisions expected. What's at stake? Hawaii case, default carry rights nationwide. Drug case. 38 states marijuana users and guns, other pending. AR-15 bans. Multiple circuits magazine limits. nationwide challenges. Illinois assault weapons ban. 7th Circuit age restrictions. Multiple lawsuits long-term, 2 to 5 years. Supreme Court likely takes a R-15 case national carry reciprocity possible. More Bruen challenges succeed states keep trying workarounds pattern clear. Gun rights expanding. Courts applying Bruen's historical test. Laws without 18th, 19th century precedent following, but it's slow state by state, case by case. Closing action plan, 10 o'clock to 10:45. On screen, action checklist, subscribe button. Your action plan for next 12 months. 1. Know your state law, changing monthly. 2. Document everything, delays, denials, violations. 3. Join gun rights groups FPC, SAF NRA, GOA fighting in courts. 4. Watch June 2026, Supreme. Court decisions will be massive. 5. Get trained, regardless of legal requirements. These 10 changes are reshaping gun law right now. Hawaii's restrictions, marijuana users' rights, ghost guns, bump stocks, domestic violence, reciprocity, May issue collapse, sensitive places, delays, training, everything's in flux. Momentum is with gun owners. But stay informed to take advantage. Subscribe and turn on notifications. When Supreme Court drops June 2026 decisions, you'll hear here first. Comment below, which change affects you most? Hawaii? Marijuana? Let me know. Share with every gun owner. Most have nitrogen monoxide idea how much changed. The fight for Second Amendment isn't over. But for first time in decades, gun owners are winning. Stay armed. Stay legal. Stay informed.